proprietorship ni hizi normal kinds of businesses zenye zina exist sahi, na hapo sioni kaa kuna a lot of issues juu ni easy to register that kind of business. Alafu saa characteristics tu ndo tuna mention, alafu tuingie kwa partnership. So ukiangalia characteristics of sole proprietorship, one, kuna single ownership. The second, kuna no separation of ownership and management juu ni the owner himself ana manage hiyo kazi. Then kuna less legal formalities. Kuna no separate entity, no sharing of profit and loss. Kuna limited liability na it's under one man control form of business. So hapo hivyo mode akitaka ionyeshe now even the difference with others, hapo itakuwa a lot of task. Juu sasa nataka tu sasa tuchambue now the Partnership Act. Oh, Victor naona umeinua mkono. Victor, proceed. Victor, umeinua mkono ama? It's okay. So tukijump into Partnership Act analysis, nataka tu tupitie juu, alafu tukitoka Partnership Act analysis tunaangalia the difference between general partnership na LLP. Na Slata umeinua mkono.
Kwani umestop screen sharing?
Hiyo imeisha. Nataka nao nataka sasa kuweka nao the Partnership Act.
Sawa.
Yeah, ni Partnership Act sasa na share. Ndio hiyo iko visible. Na Slata?
Yeah, iko visible.
Sawa. So under this Partnership Act ni number 16 of 2012. So nataka tuangalie first definition yake ya venye imedefine a partnership. Na inasema partnership means the relationship which exists between persons who carry on business in common with a view to making a profit. So under now that definition, mode akakuja in some areas hadi kama sita follow in order, nilijaribu kuziarrange vizuri. So nilijaribu kuzipanga in this order. Like kwanza niliingia instances where mtu hawezi sema ako in a partnership because of doing some kinds of work. Like for example, tukienda the first schedule, ita jump into sahi, ndio hiyo first schedule inasema when persons do not carry on business together. So at least inajaribu kuonesha some instances yenye huwezi sema uko in a partnership, na model alisema watu wapitie that area. So tukijump into, wanasema number 1, a person does not carry on a business with another merely because the person A receives a payment contingent on or varying with the profits of a business. So unapata like we kusema tu ati unapata payment is not an excuse that you have already formed a partnership. Alafu number 2, huwezi sema you are an agent of a person engaged in a business and has a contract for his numeration by a share of the profits of the business. So by you being a mere agent, huwezi sema you are part of a partnership. Alafu pia kuna receives a debt or other liquidated amount by installments otherwise out of the accruing benefits of a business. So that means if mtu ako in a partnership na nakulipa deni yako in installments, it's not a guarantee that you are in partnership with that person. Alafu number 4, if the person is the beneficiary of an estate of a person who has died and receives in the form of annuity a share of profits made in a business in which the deceased was a partner. So by you being a mere beneficiary of an estate of a person who has died, haimaanishi you are a direct partner in the partnership. And then number 5, lends money to a person engaged in or about to engage in a business under the contract for the loan. So nasikia kuna mtu akona kuna mtu anataka kutujoin, so nimemwallow. So let us continue. Asante Oliver kwa kuingia. Victor, nasikia unaongea? Yeah, proceed Victor.
Nataka kuna hii ownership na joint ownership.
Joint partnership.
Ownership na joint ownership.
Co-ownership na joint ownership.
So,
and
yes, differences.
unajua sijaangalia that area.
Differences kitu ya kwanza.
That area sina walai. Maybe kama uko nayo unaweza proceed tu.
Kwa sababu
Eh,
kwa hiyo section your section 7
yeah.
you part before part 1 those persons does not carry on a business
Yeah.
mainly because the person is sasa
Yeah.
moja ni joint ownership
Uh-huh.
ownership of the property
Yeah.
whether that person or not owns the property
Yeah.
we generate them profits made by use of that property. Ikiwa one of the exceptions. Sasa ndiko nataka the differences.
Hapo sija analyze to the extent of getting the differences. Maybe if you have that area unaweza outline tuone differences ni gani hapo. Hello Victor.
Ndio maana nauliza.
Oh, hapo sina idea. Tuko sawa?
Kiasi. So Victor anamaanisha kusema like when you're in joint ownership with someone else,
Yeah.
I constitute a partnership ama what? That's what he's trying to say.
Victor, come
Yes.
clear. Oh.
Kitu nasema.
Yeah.
Kitu nasema.
Yeah.
Joint ownership of properties with partnership.
True.
Alafu nikasema pia the ownership of a business venture is not partnership. Sasa kwa difference between the two, joint ownership na co-ownership.
Maybe for now kama maybe tutaifanya in another video, so wakati sasa tuta delve into the differences sasa. Are you okay? Hello?
Okay.
Sawa. So that's a good observation. So ukiangalia those other scenarios hapo ya mwisho ilikuwa my mic was off. So nilikuwa nasema ukiangalia the other scenarios, so the last one hapo ni if a person ana sell the goodwill of a business na ana receive in form of annuity a share of the profits of the business in return for the sale, is not a guarantee that that's a part of a partnership. And goodwill, si mnakumbuka we were told that goodwill is that business performance when it comes to the market value. So if a person is selling the goodwill of a business, it's not a guarantee that he's a partner. So at least first schedule to may tackle briefly, hadi kama we have not gone to an extent of looking at the differences. Sasa tukijump into now the other part bado under now the Partnership Act analysis, nataka tuangalie now what we mean by liability of partners. Hiyo pia ni point tunafaa kujua. Liabilities of partners imedefiniwa under section 4. Unaambiwa each partner in a partnership has unlimited liability. And ukitaka kuregister a limited partnership, the partnership shall have one or more general partners, each with unlimited liability, and one or more registered limited partners, each with limited liability. So what do you mean by unlimited liability versus limited liability? Ina venye mnyi mnaelewa, what can you say is the distinction of unlimited and limited liability? Anyone? So it's okay. So if in a layman, naweza sema when you have been told that each partner in a partnership has unlimited liability, inamaanisha that to an extent your property can be used to repay an obligation to an extent yenye huko umelipa that obligation. Remember when you are forming a partnership, kuna ile tunaitwa capital contribution. And when it comes to winding up of a partnership, they will look whether you had fully paid your capital contribution, and if you had not, na yet this partnership lazima kwanza ilipe deni za watu, they will come for your property because you have unlimited liability. And now for the limited liability, that means that your property has been secured and cannot be touched, if I'm not wrong. Now tukimaliza liability of partners, bado tutaingia deeper juu unapata in the fourth schedule, if I'm not wrong, wamesema some kinds of permitted activities that only limited partners wanaweza fanya, like imeku limit in the scope of activities you want to do as a limited partner, because as a limited partner nimesema it's like you are protecting your own property isikuje kuchotwa. So kuna some kinds of let me admit someone, so kuna some kinds of activities like one, taking part in a decision about variation of the partnership agreement, kuna kuapprove a class of investment, alafu kuna general nature of the partnership business. Hizo ni decisions zenye bado unaweza take place, na if hiyo partnership inataka kuacquire another business pia unaweza take part into, na whether a person should become or cease to be a partner, pia whether the partnership should end, because we will also look at provisions that say on how a partnership may break. Then tukitoka how a partnership may break, tutaingia on dissolution of a partnership. So taking part in a decision about how the partnership should be wound up is another area where a limited partner is permitted to take part into. Then kuna under partnership agreement, unless those rights are to carry out management functions, kuna enforcement of a partner's rights under the partnership agreement. So that's an area where a limited partner has also been permitted. Alafu pia hapo unafaa kunote kuna partnership agreement, na tutaangalia the ingredients of a partnership agreement. What does a partnership agreement entail? Then tukitoka hapo tutaangalia pia other areas zenye tuto discuss further. Then tumalizie na the permitted activities in briefly. Anaweza act kama director or employee ama shareholder, na anaweza discuss prospects of the partnership business, na anaweza consult ama advise a general partner. So Victor, if anyone can directly search, na unaweza pata a provision imediscuss who is a general partner, we'll greatly appreciate. Let me check in the preliminary provision nione kama imejaribu kudefine who is a general partner. So my screen is not responding, so preliminary. So let me search kama wamedefine a general partner ndio tusiconfuse. So in the meanwhile, kama mtu wako na kitu ya kusema, you can go ahead nikitafuta the meaning of a general partner. If not, someone may Google na atafute the exact definition. So the act has not defined. So let us continue. So unapata now tunataka kuangalia the duties of partners. What are the duties of partners to each other, to the partnership itself? Na in my notes inaanzia section 10. Section 10 ndo inaongelea now the duties of partners. Tunaanza kwanza na duty of good faith. A partner has a duty to act in good faith towards, number 1, the partnership and the other partners in the partnership in all matters affecting the partnership. Hiyo ni kitu moja unafaa kujua. Then pia a partner shall, hizi ni other duties za partner bado, shall keep other partners informed on matters affecting the partnership, na then anafaa ku account to the partnership for any profits or benefits derived without the consent of the other partners. Alafu pia si ukiangalia inakwambia a partner has a duty to account to the partnership for any profits derived by the partner from a business carried on by the partner without the consent of the other partners which competes with it and is of the same nature as the partnership business. Remember the duty above nimesoma ni ya anafaa ku account for the profits na benefits done without the consent of the other partners, business yenye sana sana ametumia the name of the partnership or business connection. If your business ainge require this name, that means he has the obligation to disclose that duty. Alafu pia ukiangalia the other provision, kuna duty of disclosure, pia ni another separate duty ukikuja ku break down the duties. So duty of disclosure on forming or joining a partnership. So in this section, what I discovered is that if you want to form a partnership or join a person huo mwenye anakuja kujoin, before forming a partnership shall disclose to a prospective partner anything known to the person which would reasonably be expected to influence the decision of the prospective partner to form the partnership. That means a prospective partner ni mtu anakuja kujoin in a partnership, na wewe being ndo mtu unataka kuform this partnership, you have that duty to disclose anything you know to that person mwenye anakuja kujoin that partnership. Alafu pia kuna another duty, an existing partner before admit a prospective partner anafaa kudisclose anything he knows. Alafu pia kuna a prospective partner, huo mtu sana anakuja kujoin anafaa kudisclose kitu yenye anajua before I enter into this partnership. And that nini ina conclude on duties of a partner. Lakini pia ukiangalia section 17, I discovered that section 17 ina form another duty to a partner, because inasema partnership bond by acts of partners carrying on business in usual manner. So unapata a partnership is bound by an act done by a partner who is carrying on the business of the partnership. This ina give a partner a duty to do due diligence when it comes to business operations concerning the partnership. So at least at that point tumejaribu ku outline some duties that partners wako willing to give the others, or pia a prospective partner anafaa kupeana to the others. So bado tukiendelea ku break down, unapata sasa tunaingia now to the substantive areas, na one of the substantive areas, let me check kama kuna any comment. Sawa. So ukiangalia one of the substantive areas, so let me get back to my screen. So ukiangalia one of the substantive areas ni under section 68, where sasa inakuja kuongelea about registration of a partnership. Na hiyo section 68 is very important because you must understand how a partnership is formed to the fullest. So najaribu ku get back to my screen. I'm trying to look at, naona tu imeandiko tu sharing like na siwezi rudi. So in the meantime, mtu anaweza fungua hiyo section 68. Nimeshindwa ku get back in my screen. Hiyo section 68 nilikuwa nimeandika mahali that if you want to form a partnership, you should deliver to the registrar a statement with the following. Kitu ya kwanza, hiyo statement ikuwe na the name, ikuwe na addresses of the partners wenye wako willing to form this partnership, ikuwe na name of each proposed partner, amount of capital contribution by each partner, na kukuwe pia na location and address of the office mahali unataka ikue, na kukuwe pia na date of formation if it's an existing general partnership yenye sasa unataka maybe upgrade to a limited partnership. So by that I believe is imeprovidiwa under section 68. Nimejaribu ku get back into my nini, maybe I can pause kidogo, maybe I'll get back. Alafu pia unapata under now section 69, tukimalizia na hii process ya registration, inakuja kusema now the registrar akiwa satisfied atapeana a registration certificate after fully registration process has been observed. So I believe at that point tumemaliza the process of registration of a partnership. In case mtu ako na question, but pia niko na kitu ya a matter arising because tunataka kwanza tuangalie what a partnership agreement entails and whether it's a requirement when it comes to registering a partnership. So if you look at the requirements of if you look at the requirements of nature, also I'm seeing Naslata nature of business. So nature of business also Naslata has said that is a requirement when it comes to registration of a partnership and partnership. So nataka kujua, is a partnership agreement compulsory when it comes to a registration, ama you can draft a partnership agreement later after registration, and what are the essential features of a partnership agreement? Naslata, please continue. I see you have raised your hand.
Yeah, I think before you enter into a partnership with anyone, they have to draw your partnership agreement ama your partnership deed. It entail what the business is all about, how they're going to manage the funds, like venye watafanya hiyo partnership venye itakuwa, like what are agree on their terms venye kutaenda in that partnership. And the section I don't know 53 wenye umesema ndo ita bring about other details zenye ziko kwa partnership agreement.
Wow, Naslata, hiyo ni poa. Na do you have the provisions zenye a partnership agreement iko nazo ndio tuone the essential requirements in the partnership agreement?
Unless I check, sijashika kwa akili.
Sawa. Mtu mwingine yote pia anaweza kuwa akiangalia while I'm also looking at it. Ndio niwasome the essential requirements in a partnership agreement, na nimepata inasema number 1 is that wanasema the parties to the agreement, pia majina zao lazima utasema, the nature of the business, na kuwe na the name of the firm, na the name of the firm, wanasema the name should not contain the word limited as it is illegal. If you are forming a general partnership, this is a kawaida, don't include the word limited if it's not, because that will be illegal. Then the partnership may indicate dates of commencement and dissolution. Then other things ni capital of the firm and of the individual partners. Lazima indicate what every partner anakuja ku contribute and must contribute equally towards the losses. Na all partners are also entitled to share equally to all profits zenye utapata. Hizi ni all, or still bado msisahau tuko in partnership deeds ama partnership agreements. Ndio tunaangalia the features of it. Now pia kukuwe na clause of salary and profit entitlement of the partners. Remember, partners can agree not to share equally and have a formula for sharing. So that formula ikue tabulated pia hapo. Remember ni poa pia uandike the formula of sharing the profits, because unapata ikikuja kwa calculation of goodwill, they require to have the capital contribution formula for them to share the goodwill amounts equally. Remember a goodwill ni hiyo pesa yenye after selling the business ni yenye sasa itagawiwa watu. So Naslata, I see you have a contribution, please proceed.
Swali,
Yeah.
like easy things zenye ziko entailed in the partnership deed na zenye ulikuwa umesoma before, the ones which are required for a partnership to be registered, are they different ama zinafanana?
Yes, Naslata, they are different because for partnership agreement, I asked the lecturer na akasema it's not a must ikuwe mshamaliza the agreement when it comes to registration of this business. Lakini unapata partnership agreement imeongeza so many clauses ndio juu in order, because hawataki kukuwe na future conflicts when it comes to maybe matters of management of the business. Pia ni another clause inakuwa inahitajika, na duties of the various partners. So now you see a partnership agreement go to an extent of mentioning the duties, ndio usikuje ukafanya duty yenye ita go beyond your powers. Unaona? Now pia kuna decision making, how will decisions be taken in that partnership. Kuna banking arrangements, kuna the firm's accounts pia zinafaa kuwa included. Kuna admission and expulsion of partners as well as retirement procedure unafaa ku outline. Kuna valuation of goodwill report. Unakumbuka paka hivi kwa partnership unaweza uza a partnership na iko na jina mzuri, so kukuwe na valuation of goodwill report. Kuna arbitration clause. Remember, partnership haziko pale kupigana, ziko pale pia to also form good relations with each other. So it's better they solve their disputes during arbitration rather than court disputes. That's why hizo ndo elements zinapatikana kwa general kwa partnership agreements ama partnership deeds. Now tukitoka hapo, I believe everything now is clear. We can go now to the sections zenye zinasema how now a partnership may break up. What are these scenarios zenye partnership inaweza break up? Na ni kama niliweza ku retain to, kuna venye nini yangu imejificha, one of the tabs yenye ime outline this, let me look for it. Okay, nimeipata. So breakup of a partnership iko under section 35. So let me take you there. Section 35, tuone nini inaongelea when it comes to breakup of a partnership. So breakup of a partnership breaks up if the following happens. The following ni hizo zenye zimeandikwa hapo. If the number of partners falls below 2, na if the partnership was for a fixed term and the term expires, then an order to break up the partnership may be made by the court on application of a partner. Remember, this order yenye itatolewa na this court ni the order that imeandikwa in section 44 of the Partnership Act. Section 44 ndio hii, na imeongelea now on power of court to make order removing partner or breaking up a partnership. And the court may, on the application of any partner, make an order removing the partner from the partnership, removing another partner, ama breaking up the partnership. So we are interested na hiyo part C, hiyo order ya ku break up the partnership. So let us get back to section 35 tuangalie the other provisions. Kumbuka pia a minister anaweza andika to the court make an order under section 51, na hiyo order iseme we want to break a partnership, na pia an order is made by a court under section 51(2) of the act. If we look at hiyo section 51(2), ina provide that section 51(2) ina provide that on application under subsection 1, the court may make an order for the partnership to be broken up on such terms and conditions as it may consider appropriate. So in kama ina support it is read together with your subsection 1 on application of the minister. So bado turudi kwa hiyo section 35 tuone whether we have lost anything when it comes to break up of a partnership. Now hiyo bado under section 35 tumemaliza. Alafu pia wanasema a partnership whose term is not fixed or that is for a fixed term and one of the more partners has at any time in the course of partnership ceased to be partners. Ukumbuke this subsection inasema if ilikuwa partnership na hiyo partnership term yake ilikuwa fixed, then one or more partners at any time in the course of the partnership cease to be a partner, the partnership shall be dissolved if at least half the number of partners decide that the partnership should be dissolved. So you may give another area where someone may break up a partnership. So if we can also proceed further, tunaangalia an agreement to break up or to continue a partnership may be inferred either from the fact that the partners cease to carry on the partnership business or from the fact that the partners continue that business with a view to making a profit. So si lazima ikuwe written, inaweza kuwa inferred through the conduct. So if both partners wakikataa maybe to take up matters before the court na ilikuwa maybe a law firm partnership, itakuwa directly inferred under provision section 35(6). So unapata after all those provision kuna effects of a breakup. Now under section 36 ndo unapata kuna hizo effects, if it's all clear hapo. And Victor, we can hear your voice. Victor? Okay, so let us continue. Yeah. So I was saying this, kidogo tu screen yangu inaleta issue kidogo. I was saying that So I was saying, so sorry for that. I was saying that hiyo ilikuwa effects of a breakup after tumeona hapo under hiyo section 35. And unapata effects of a breakup, number one, kuna inaweza lead to dissolution of a partnership. Kai, nini yangu imepotea. Nini yangu imelost. Sijui mahali imeenda. Backfire hivyo. So, under the effects of breakup of a partnership, unapata tu ni kama hizo tatu. It's either the dissolution of a partnership to occur, ama kukuwe na winding up of the partnership, ama winding up of the partnership by a liquidator. So unapata the winding up of partnership by partners iko under section 40. That's the next area tutaingia. Nao pia tutaingia the winding up of a partnership by a liquidator. Sasa hapo lazima tutaanza kukua more procedural because iko na steps involved. Na ikiweza kuja kama swali hadi main exam, you find that many people who wana confuse winding up by partners na winding up by a liquidator. Na Slata, naona umeinua mkono. Continue.
Na nimeona kwa notes na place waliongelea about liabilities of the partners.
Sasa
If unaweza touch on it.
sawa sawa. Unakumbuka tukianza nilimention on liabilities of partners na nikakwambia ni iko under section 4 of the Partnership Act. Na section 4, if I can show it also, section 4 of the Partnership Act inasema that each partner in a partnership has unlimited liability. Na hiyo ndo kwanza tulisema each partner akona unlimited liability. Hiyo ni kitu moja unafaa kujua. Now hiyo tu ndio inasema essential requirements for a limited partnership. Hizo kitu ya kwanza unafaa tu kujua what's unlimited liability. Unlimited liability inamaanisha when this partnership itashindwa kulipa their obligation ama debts, your property zitakujiwa ifulfill this obligation ama debt. But once you have a limited liability, that means your property cannot be touched. Hiyo ni kitu moja model alitaka watu wajue. Na if I can look under section 8, you can also see that partnership to have unlimited capacity. And section 9 inasema the capacity of a partnership as a legal person is unlimited. A partnership shall not employ a partner as an employee of the firm. So unapata generally section 8 aiongelei on limited liability, inaongelea now the unlimited capacity of a partnership to an extent. Under section 9, a partnership is not capable of committing an offense except so far as is provided under any written law. So generally the act may provide the liability of partners. Na naona Mark Okelo. Mark. Na Slata bado umeinua mkono. Please proceed.
Yeah, like nilikuwa nasema hiyo liability of incoming partners, your outgoing partners and dead partners, like hizo.
Sawa. Maybe Mark Okelo ako na notes. Mark, do you have the notes to those liability of partners? Mark kwani aliingia na akapotea? So Naslata, in the meantime, I'll be looking for those liabilities because kitu yenye naona kwa the notes hapa ni haya, ndakutafutia. Yenye naona ni relationship of the partners with third parties, existing partners na liability of incoming partners. Nimepata the area yenye unataka niongelee. Now, wacha tuanze na liabilities of the partners in general kutoka juu, si ndio?
Alafu haiko kwa Partnership Act.
No, Partnership Act.
Section.
Partnership Act unaona tumeongelea tu na ni hizo tu hivyo.
Hizo sawa.
Ni hivyo tu ndo Partnership Act provide. So, if we look now at the notes, moja nasema partners are jointly liable for all debts and obligations of the firm incurred while they are still a partner. This includes a firm contract. However, when it comes to torts of any partner and also misapplication of funds or property, the liabilities of the partners is both joint and several. In order that responsibility it may attach to a partner, for that responsibility to attach to a partner for torts or frauds of their fellow partner, the partner must have been authorized to do the act in the first instance. The action or omission must have been done on behalf of the partner and they have ratified it. The act or omission is permitted in the course of the partnership business. So remember hizi notes hazina hivyo flow ukisikia hadi nikisoma because it was a first kusomewa kwa dedicated. Marco Kelo, naona pia umeinua mkono. Please proceed.
Victor,
Yeah.
manze hapo hizo notes manze mnatoa wapi, ziko wapi?
Notes ni zile za mode akisomea wasee, akidictate. Sasa unapata hazina flow, unaget? Lakini kitu yenye nataka upate, kuna hii kesi yenye inaitwa Lloyd versus Grace Smith and Company. Lloyd versus Grace Smith and Company ndio ime give rise to liabilities of partners. Maybe mniallow kidogo ni search on that case. Bado tu tukiwa hapa ndio tupate hiyo flow. Hii kesi ilikuwa inasema nini? Unajua kutoa pia notes za mode inaleta different definition. Lloyd versus Grace Smith and Company. Hii ni landmark case. In 1912 ndio iliokaa. So acha niandike case brief ndio tusome case brief yake tuelewe. So while it's loading, mtu yote ako na any other suggestion? Bado ina load? Hai, imefunguka. So case mine huwa refu. So haya, acha ifunguke. Acha ni share the screen with you pia. Hapo kwa let me share. A window. Is it visible? Lloyd versus Grace and Smith Company. So wacha ni mnaona screen?
Zi.
Junaona ipop hapa. Ionekani? Naona nikaa inakataa kupop up. So acha niwatafutie generally venye inasema. Acha nione kama nda extract hizo quick facts mbio. A principal is liable in damages for the fraud of his agent, whether benefited thereby or not, provided the agent is acting within the scope of his employment. In a case where a clerk purporting to act on behalf of his employers as solicitor obtained control of and embezzlement of the property of a client, it was held that the fact that the clerk was apparently invested by the employer with the power to act for him was sufficient to make the employer responsible for his fraud. Na pia imesupport na kesi ya Baswick versus English Joint Stock Bank. So unapata in that case yenye nimefungua ni original case na ni wide. I provide the link to the case maybe after this video, but generally mmeshasikia what the case is talking about. Inaongelea on kama umepewa this mandate, umekuwa authorized for you to do this act and you go ahead to an extent that you ni clerk na una work for a solicitor, unafanya kazi yenye hauna its authority ama umepewa authority na employee, that act ama omission na ulikuwa umepewa authority na the employee imebound mpaka the employer. So at least hiyo ndo the landmark case so far tume encounter, Lloyd versus Grace Smith and Company, a case that occurred in 1912. Then unapata kuna liability of incoming partners. So hapa ilikuwa a person who is admitted as a partner into an existing firm does not become liable to the creditors for anything done before he became a partner. However, the right of the
Cha.
yeah,
So in that case, hiyo Lloyd versus hiyo sijui nani,
Grace Smith and Company, yeah.
Huyo clerk mwenye ana act on behalf of the huyo owner when like he happens to cause like any problem ama and out of law. Sasa nani atakuwa liable, the owner ama the huyo clerk, the agent sasa?
So hiyo kesi venye nimeelewa wanasema if the employer alikuwa amepea this clerk the authority will also bind the employer. Una get?
Oh.
Yeah. Sasa hiyo ndio
Lakini
yeah.
Kwa hizo note za madam aliandika that case is
Yes.
a case of separate liability.
It's a case
Like
of
amesema
separate.
partnership there can be in a partnership there can be joint liability or separate liability. So in this case na hapa kwa notes amesema in this case hii kesi ni kesi ya separate liability.
So
Sasa kama ni
ameprovide
separate liability.
yeah, please continue. Sasa unapata
Kama ni
for us to understand this case mali inaingilia we will have to read that case hiyo ikiwa mzima and the link na watumia maybe ni poa hadi niwatumie the link in the comment section. Mtu anaweza kuanga akitafuta maybe it's case brief mahali ndio before hadi tumalize this session akuwa anatuambia what the case was saying. If you look at the comment section nimetuma hiyo link, hiyo ndio iko na the original case. So mtu atatafuta case brief then atatuambia where the case falls because hizo ni the notes za mode ni kama siku separate. Are you okay at that point? Sawa. So under liability of incoming partners hapo sijaona any provision but I believe ni kama Partnership Act imeongelea on incoming. I will look for it project now the act. Alafu pia the next area yenye mode pia alisema alikuwa anataka liability of retiring and outgoing partners. Kumbuka hiyo ya kwanza ilikuwa incoming, now this one are retiring ama outgoing. Now the partner does not stop being liable for debts incurred before becoming a partner. However, they may be discharged by an agreement between themselves and members of the firm. Hiyo ilikuwa hivyo theory. Then akasema liability of dead partners. Under liability of dead partners wanasema the estate of the deceased partner will be severally liable in the due course of administration for those debts and obligations so far as they remain unsatisfied but subject to prior payment of separate debts. So unapata if a person alikufa na alikuwa a partner kwa hiyo partnership na imechukuliwa na maybe new successors wakikuja kuinherit the property, the estate itakuwa bado severely liable in the due course of administration for those debts. So kulipa deni hiyo estate yake pia bado itakujiwa hadi kama he is a dead partner. Alafu pia kwa liability of minor partners mode akasema check on the case of Begel versus Miller 1903. Maybe acha pia nitafute case brief ya hiyo naito Begel. I will also attach the nini hapo. Okelo, Mark, you should also be looking on the first case brief, then na Slata utaangalia pia now the second case brief ndio tuone where these cases lie na tusikie the story behind it. So the second
kesi ya pili ni gani?
ndio inataka kuambia inaitwa Bergel, BERGHEL versus Miller, MILAR, a case that occurred in 1903. Maybe italeta case brief directly. So if we look at this case, naangalia zile sites zenye huwa zina provide case briefs na ni kama waja provide its case brief. So allow me to continue while someone anaangalia on liability of minor partners according to that
Victor?
case. Yeah.
Repeat hapo liability of outgoing ama retiring partners please.
Aya, liability of retiring and outgoing partners ilikuwa the partner does not stop being liable for debts incurred before becoming a partner. Umepata hiyo part?
Expound
The
before
part,
becoming a partner as in
So if I get the definition, wanasema the partner does not stop being liable for debts incurred before becoming a partner. So unapata mtu anaweza kuwa liable hadi kama huko umejoin before. So unakumbuka hapo kuna duty to disclose to a prospective partner ana join in the partnership. So unapata
Yeah.
they can disclose to you that this partnership iko na a certain debt, na therefore you will have to contribute this amount when it comes to also the sharing of our goodwill. Juu anakwambia hii kitu already iko established, so you will have to pay kwanza 20,000 before we begin to speak. Alafu pia wanakwambia pia maybe on capital contribution you will give a contribution of 120k. So that means maybe in this 120k imekava mpaka debt yenye wako sure itamaliza, then later ina turn out that bado the amount is not enough. That means edi kama huko umejoin at that time, the partner does not stop being liable for debt incurred before becoming a partner, ita apply because maybe wame realize haya tulikuitisha a capital contribution of 120,000 and yet deni yetu kumbe hatuko tumecalculate vizuri juu tuko na lot of debts, and that will also mean however, sikia venye moja anasema, however they may be discharged by an agreement between themselves and members of the firm. Remember hapo hivyo chini ni kwa partnership agreement, as we started nilisema a partnership agreement may contain a clause on capital contribution. Na maybe you can decide to talk with this existing partners, uambie mi naingia kwa hii partnership yenyu nisibebesho mizigo ya I'm not liable for debts that you entered into while I was not in. So that agreement ndo itakuwa imekusaidia when it comes to liability of you as an incoming partner.
Oh, nimeelewa. Na ya retiring.
So for retiring, sorry, ni kama na confuse the terms juu wanasema liability of retiring and outgoing partners, wanasema maybe sasa unataka kuenda na kuna hiyo provision of a certain duration yenye you can be liable, na ikipita, if I can remember in the partnership act ndakutafutia the provision, wanasema maybe the 6 months before, unaona after umesha kuwa partner ukae 6 months hivi ama 1 year, look for the provision, then you won't be liable for debts zenye zitakuwa sasa zinachukuliwa at that time. Sijui kama hiyo part iko
Nimeelewa.
ndakutafutia hiyo provision, niliona in the partnership act.
Utanitumia tu partnership act yote.
Sawa. Aya.
Sasa niangalie case hiyo Beagle versus Miller.
Beagle versus Miller. Case brief yake pia. Yeah. So hapo tuko sawa, si ndio?
Yeah, tuko sawa.
Aya, sasa juu nilikuwa najaribu kuangalia hiyo liability of incoming partners. Wanasema a person who is admitted as a partner into an existing firm does not become liable to the creditors for anything done before he became a partner. However, the right of the creditors to sue the incoming partner may be acquired by novation. Sasa hiyo, what is the definition of novation? Unaona ni kama nimerealize, ni kama nilikuwa ina confusion nikuexplainia when it comes to outgoing na confused na incoming. Sasa unapata creditors wanaweza sue.
Incoming ndo yenye ulikuwa na explain sasa. Kikana then you find that they already had debts but you can talk hivyo. Hiyo ndo ilikuwa incoming.
Sasa hiyo ndo incoming, na unapata wamesema directly you are not liable, but unasikia creditors again they can sue under novation. Sasa ndo naangalia meaning of novation in law. Wanasema a novation is an agreement made between two contracting parties to allow for substitution of a new party for an existing one. This is an incoming person, remember? Na wanasema once unaingia in this partnership you are not liable for debts zenye zilikuwa incurred while you are not present. So unaona that's a good idea. Now pia notes inasema however a creditor may sue you when it comes to novation claims. Na ukiangalia meaning ya novation inasema ni a novation is an agreement made between two contracting parties to allow for the substitution of a new party for an existing one. Maybe that's a complex. Acha niangalia simple. A novation is the act of replacing a contract with another contractual obligation requiring the consent of all parties involved. Maybe sasa hiyo ni another, so in short ni kama wanamaanisha well, ni kama ukiingia then waform another contract with the creditors na at the same time ndo unaingia, they will be able to sue you because this is another contractual obligation and it has replaced the first one yenye ulidhani unaingia into. I believe hapo at least iko clear, si ndio?
Yeah.
So the areas zenye tulikuwa tumeconfuse ilikuwa hiyo liability of incoming partners, na ndio hiyo tumesema you are not liable for the past but you can
So
be
you're
sued
not
under
liable.
novation.
Ile ingine tulikuwa tuna confuse.
Exactly, hapo ndo nime
Because
notice.
umesema like you will be liable for the debts hata kama you weren't a member of the firm.
Exactly, but sasa unapata but hiyo provision ni kama ina apply on grounds of creditors kusue the incoming partners under novation, under hiyo doctrine of novation. Unaona? Aya. Sasa hapo tuko sawa, si ndio?
Yeah.
So far tume encounter the two cases. So nikirudia on liability of retiring and outgoing partners, juu nilikuwa nime confuse, inasema the partner does not stop being liable for debts incurred before becoming a partner. However, they may be discharged by an agreement between themselves and members of the firm. So unaweza acha kukua a partner in a partnership for a certain duration, then mwingie in an agreement niwaambie whenever mta incur any obligation ama debt, don't include me. Ama unaweza pata pia umeengage kwa hiyo maybe a duration of hiyo within 6 months after termination, bado utakuwa held liable when it comes to retiring and outgoing partners. At least hapo sasa tuko sawa, si ndio?
Yeah.
Hizo concepts zilikuwa confusing kidogo.
Kwa mimi confused.
Sawa. Sasa utaangalia hiyo kesi ya Lloyd na hii ya Begel versus Miller.
Sawa, tutaangalia tu baadaye. Tuendelee.
Sawa. So tuendelee na analysis ya hiyo partnership act. So under partnership act, so tunaenda kwa tumeongelea break up
effect of break up.
Haya, tulikuwa kwa hiyo ilikuwa section 36.
Kuangalia winding up
By a partner.
No, ama tumalize zenye madam amefunza class.
Madam
fanya zote bado limited.
Madam ameguza winding up.
Bado hajagusa.
Kama
amefika huko.
Amefika wapi? No, according to your notes amefika wapi?
Niangalie.
Haya, tebu angalia uniambie.
So far tujafanya ya third party peke. Relationship of partners with third parties. Tujafanya, alafu the last class alifunza kuhusu your liability of minor parties. Amefunza partnership property, dissolution of partnership. Amefika nini?
Amefika.
Amefunza dissolution of partnership. Alafu akamalizia limited partnership. So like 3 things. Tufanye partnership property, dissolution of partnership and limited partnership.
Aya, sawa. So tunaingia hapa kwa winding up of partnership by partners, ndio? Under section 40. So nimeclick hiyo 40.
Amecover so far
Dissolution.
Ama tunaweza fanya tu yote.
What's the difference between
winding up by partnership, by liquidator, tufanye tu.
Juu ni area gani anataka specifics, ndio? So ukiangalia mambo ya winding up by partners imeoutlineiwa under hiyo section 40. Now niliamua kuiweka in steps. So unapata step number 1 hiyo section 40, unaambiwa a partnership may be wound up by one or more partners. Hapo tuko sawa, si ndio? Then step ingine after washaamua agreement ya ku wound up, kunafaa kuwa na distribution of partners assets on wounding up. Na unapata under your distribution the following rules must apply. Rule ya kwanza ni payment of any amounts owed by the partner to the partnership. Iko sawa, si ndio? Ulipe deni ya partnership. Then wanasema pia the partnership shall pay all amounts it owes to persons other than partners. Ilipe watu wengine hiyo partnership. Then that wanasema pia payment of amounts owed to partners. Kama pia hiyo partnership ina owe its own partners pesa, iwapatie before ianze kufungwa. Then kuna sharing of any surplus assets. Ishare kwanza any excess assets iko nao amongst the partners. Alafu pia unapata partners contribution towards deficiency. Deficiency in terms of ni kama deni mlikuwa mnalipa na ikakosa kutoshea. So that point hamtakubali iende into winding up kama mja agree venye mta meet up that deficiency. At least at that point tuko sawa, si ndio?
Yeah.
Sawa. So tunaingia now the next stage, itakuwa section 42 on dissolution of partnership which has broken up. Unakumbuka huko juu kulikuwa na instances where a partnership may break up.
Yeah.
So hiyo section 40 tumeongelea dissolution by partners themselves. Sawa? Ndio sasa tukuje now under section 42 inaongelea now where ili break up itself, maybe the number ikakuwa less than 2. Unaona? So hapo ni kama tu bado unajirudia juu unasema before ikuwe wound up by hiyo under section 35 by hiyo breaking, inafaa kuwa all partnership property is distributed to persons entitled to it. Any trust property ikuwe transferred to a trustee ama a person entitled to it, na kusikue na liabilities outstanding against the partnership, na kusikue na claims outstanding by or against the partnership. Na ukiangalia now section 42 inatuambia if a liquidator has been appointed under section 53, the liquidator has ceased to hold office without being replaced. It's another ground where a partnership may be dissolved. So unapata the next step 3. Kumbuka nilizi break down into stages. Now step 3 nimesema a power of the court to appoint a liquidator. I hope tuna flow in this dissolution process, ndio?
Yeah.
Haya.
Yeah.
So when it comes to power of the court to appoint a liquidator, iko under section 52. So ukiona kwanza before tuingie 52 unapata minister pia nilikwambia anaweza make an order to break up a partnership.
Yeah, minister umesema minister or a court order.
Ndio anaambia the court that ako satisfied hiki kitu iko nini wound up. So tuko kwa power of court to appoint a liquidator. Sa unapata this is the step 3. This will occur after an application from a partner, a person interested in the winding up of a partnership, or a creditor. So hii ina occur when those people ndio wamechallenge the court ndio appoint a liquidator. Unaona? Now pia unapata hiyo order appointing a provisional liquidator. If an application sa imeshapitishwa under section 52 has not yet been determined, the court on the application of a partner, a person interested na creditor inaweza make an order appointing a provisional liquidator. A provisional liquidator inamaanisha for the time being atakuwa na act kama liquidator. Unaelewa?
Yeah.
So because if you look at company law wanasemanga liquidator anatoka from the company. Ni kampuni ndio inaamua who will be their own liquidator. So if at that time koti inaweza appoint a provisional ndio act as an interim. Ako tu ameshikilia. So unapata ukitoka hapo unaingia the next stage, step 4. I hope bado tuna flow juu nilikwambia step 1 ilikuwa distribution. Kwanza step 1 ilikuwa section 40 ya kurecognize that inaweza kuwa wound up by partners themselves. Hiyo ni one ground. Number 2 nikakwambia if wanataka kuenda wao wenyewe they should make sure wamecomply na rules zenye zina govern the distribution of partners assets under section 41. Then nika break down under section 42 nikakwambia dissolution of partnership which has broken up. Kumbuka hizo first steps kwanza ni za kuonesha grounds on which a partnership may break. That means if the lecturer now atakwambia discuss on how a partnership may break under a liquidator, now you will jump directly to section 52. Unaona venye zina flow? Na kama anataka uoneshe how it will be wound up by partners themselves, una jump straight to section 40. So kutoka hapo nimekwambia now we are going to the second schedule. The second schedule inasema winding up by liquidator. The second schedule of the Partnership Act. So unapata under this second schedule ndio unapata liquidator akiwa sha kuwa appointed, kuna some effects. Na effect number 1 yenye niliona ni major ni that powers of the partners zina cease. Wanacha kuwa partners at that time, hizo powers zao zinaisha. Then kitu ingine important nilinote ni each partner and each person interested in the winding up has a duty to cooperate with the liquidator. Huyu liquidator ni mgani? Mwenye aliappointiwa by the court under section 52. Now pia general duties, hizi ni vitu zenye tu unafaa kujua who is a liquidator na duties zenye anafaa kufanya. So duties anafaa kufanya ni get in and realize the partnership property, ajue ni gani. Anafaa kulipa debts na discharge liability of the partnership na distribute any surplus profits to the partners. Na anafaa kuensure that all trust property imepewa to trustee ama persons entitled to them. So general powers pia unapata kona approval of each partners na with the sanction of the court. Hizo zote tu ni vitu common. Contracts entered into by the liquidator ujue zitakuwa binding. Court's power to vest property in liquidator. So unapata hii ni another key point unafaa kunote. Hii court's power to vest property in liquidator. On application of the liquidator, the court may by order direct that all or any part of the partnership property is to vest in the liquidator by the liquidator's official name. This means wakati sasa hizi partnerships zinakuja ku assent to their maybe assets zenye ziko scattered, koti imepea this liquidator this role ya kuconvert this property iko in the liquidator's official name, because anafaa kuensure that all property pia imepass to the trustees. So na kama uko na disclaimer, you can challenge the minister concerning the onerous property under hiyo 7. Now effects of partnerships insolvency inaoccur if the partnership is unable to pay its debts and there is no reasonable prospect of its becoming able to pay its debts. I believe hiyo tu ni general knowledge ya if tu partnership imekuja kukua unable to pay its debts, liquidator pia kuna venye ata make reasonable attempts to value its asset and pay its debts. Alafu unapata kuna kitu hapa pia nimeona ime catch my eyes, ni a liquidator who without reasonable excuse fails to comply. So unapata pia liquidator akikosa comply with some of the duties anafaa kufanya, amecommit an offense. So unapata pia kuna annual accounts. The liquidator anafaa prepare a full and true statement of accounts concerning the conduct of the winding up during that year. Na anafaa convene a partnership meeting for the purpose of laying the statement of accounts. Hizo annual accounts ni another step unafaa pia kunote. Na unaona anafaa kuitisha meeting na each partner anafaa attend the meeting or any person interested in this meeting. Then anafaa pia prepare to final accounts. These final accounts contain summary of his receipts and payments and how the partnership property and trust property has been disposed of. So unapata kulikuwa na hiyo annual account ya every year na itishe meeting, then next step ni final account na a give explanation of property venye amegawanisha na venye zimeenda. Now power of court to order an account, wanaweza itisha pia, koti inaweza itisha account ifanywe tena ama if the account is not clear. Alafu pia resignation of a liquidator pia naweza amua kujiondoa. Appointment, release, if the liquidator no one attends the meeting nini. So ujue tunaangalia zenye zina follow the steps of winding up, then expenses of winding up, all expenses yes.
No, nasikiza.
Oh, unasikiza, sawa sawa. So the last step itakuwa expenses of winding up, all expenses properly incurred in the winding up, including the remuneration of the liquidator or any provisional liquidator appointed by under section 55 are payable out of partnership assets in priority to all other claims. So unapata this liquidator ndio atalipwa from the money ya partnership assets. So I believe at that point tumepata the general overview. Juku kwingine sasa ina put emphasis. Unaona kama functions of provisional liquidator, huo mwenye aliletwa na koti ni kama inajirudia in some way. So at least for now unafaa kujua that the steps to follow once umeulizwa discuss the winding up procedure, utakuja na grounds kwanza zenye inaweza kuwa wound up. Number 1 ni through partners under section 40. Then kama ni hao partners wameamua to go into the winding up, wa distribute the assets under section 41 by those rules. Then kama ilikuwa already broken up, iko ready to go for dissolution under section 42. Then power of the court to appoint a liquidator is another ground under section 52. Then uingie direct kwa second schedule if the lecturer anataka you discuss specifically on how a partnership will be wound up by a liquidator. And I believe for the second schedule ime outline now these steps, na vitu zenye ufai pia kusahau ni preparation of accounts, annual accounts, uitishe meeting, then after this meeting you prepare what we call final accounts. So I believe at that instance tumediscuss into details what it concerns ukiongelea on matters winding up. Are you okay on your end?
Yeah, I'm fine.
Sasa hizo case law mbili ndo so maybe I look on the case briefs then I present to you. So other area umesema Mode anataka ni area gani? Naslata? Sawa.
Let me check.
Oh, okay.
Partnership property na limited partnership.
Oh, so actually hadi today
Partnership na limited partnership.
okay, so
Ulikuwa umesema baadaye utafanya general partnership.
Nilikuwa na the difference. Acha nione kama ita project. Acha nikuprojectie in my screen.
Yeah, the difference between.
Yeah, acha nikuoneshe the difference ndio at least uone mtu anaingilia wapi when it comes to showing the difference. Let me project the area. Sijui mbona ipop. In my end inaonesha, lakini when it comes to sijui kanda itrace hapa. Let me click it ndio ifunguke. Haionyeshi, si ndio? Acha nifunge hizi zingine, hizi tabs. Wow. Sasa niko sure itakam sasa. Haionyeshi, si ndio? Imeonyesha the difference between general partnership versus
the differences between general partnership.
Yeah.
Limited liability partnership.
Bas. Sasa acha tuflow na hiyo ndo.
Imeonyesha.
Sawa. Acha tuflow na hiyo. Ndio at least uone where the confusion maybe huwa inakuja when it comes to the difference between the two. Na hadi utapata some areas tunaweza kuwa tulienda deeper sana. So unapata the following discourse gives an in-depth comparison of the concept of LP and LLPs as entrenched under the Partnership Act number 16 of 2012 and LLP Act number 42 of 2011. So therefore the study is based on a pure comparison of the two acts. So hizo ni introduction to jump into straight. To avoid confusion, the study starts with the liability of partners in a limited partnership. So for a limited partnership to be registered, the partnership shall have one or more general partners, each with an unlimited liability, and one or more registered limited partners, each with limited liability. So unapata hiyo 3 inamaanisha ni footnote iko huko chini nda kuhighlightia utaziona. So furthermore, the difference between the partners has been provided in that a general partner shall be held liable for all debts and obligations of the partnership, whereas a limited partner shall be liable for the debts or obligation of the partnership to the extent of the amount contributed to the partnership at the time of joining the partnership. So these notes ndakutumia the link for you also to open the same and make a summary later.
Okay.
Aya, so unapata, let us continue. The role of the limited partner has also been
Just
restricted.
highlight to the difference.
Ndo najaribu kuzi-highlight na inakaa bado ni a lot of literature. So unaona umeniuliza mpaka property of the partnership. I presume my battery is low, so acha ni charge nini. So I presume hivi tungefanya the difference between difference between general partnership na LLPs in a separate meeting. Unaniget? After now,
But tunatumia
okay. Ndakutumia this link for you to make notes, ndo tukipatana tukue tumefanya all this. Unaona venye ni detailed? Yeah, so tutafanya hivyo, alafu also on just to juju ndio tusitoke kama tujongelea on LLPs. It's a conclusion statement. Hii ndio the last part, kwanza nataka sijui kama ina project on your screen. Like nataka kukupea some specific elements that constitute an LLP, na unafaa kujua hivi that an LLP, limited liability partnership, is a separate legal entity from its partners. In this respect, it is similar to a company and different from a typical partnership. Unasikia ni a separate legal entity from its partners. That's why watu wengi wanataka LLPs, because inamaanisha you are a separate legal entity. Hizi other partnerships zimekubound.
Yes.
Wana nisumbua. So nasema partnership or partners of an LLP are not liable for the firms. Naslata.
Bro.
Pole, ole kuna msena nisumbua. Sawa, nilikuwa nasema
Malizia bana.
aya, so point ingine unafaa kunote ni partners of an LLP are not liable for the firm's debts and obligations, nor are they liable for each other's debts and obligations. This is not the case with general partnerships. Unaona ikikuja kwa general partnership, I am liable for the debts yenye utakose in the partnership. But ikikuja kwa LLP, kila mtu na madeni zake. Na ndio kwa maana unapata most law firms zinaingia in form of LLPs.
Kila mtu ako liable.
Kila mtu ako liable on his own. Unaona? Unaget? Yeah. Alafu kitu ingine, however, individual partners in an LLP are liable for their own wrongful acts or omission. The LLP is also liable for a partner's wrongful acts or omission to the same extent as that partner, where the partner is engaging in the LLP's business or acting with its authority. Kama upartner akona authority ya LLP, the LLP itampea cover. Unaget? So, this provision inasema individual partners in an LLP watakuwa liable for their own wrongful acts or omission. At least, ukisikia hizo parts mbili, inakuja kuonesha why inakuja kukua a new business vehicle in Kenya, as the report na kutumia imeandikwa na hii law firm kubwa Kenya inaitwa Bowman's Law Firm. Wameandika how an LLP inakuja kuwa a new business vehicle in Kenya and why people should move to LLPs. So unaona, at least ukisoma that article ya Bowman's, now tukikuja kudiscuss na difference between general partnership na LLPs, utakuwa unakuja kuona ni angle gani nakuja nayo. Unaget? Yeah, so acha nikutumie mpaka hiyo link. Acha nizikopi hapo kwa comment section, lakini bado ndakupestia.
Sawa.
Haya ndio.
Hata unitumie WhatsApp.
Ndakutumia WhatsApp. Ni venye sana
Like kuna question Victor alikuwa bring up
Yeah.
ile difference between joint ownership na co-ownership.
Difference
Tutaiangalia ina meeting.
Sawa
Difference
sawa.
between
Sawa. Sasa
co-ownership na joint ownership.
sawa. Sasa unaona
Partnership, I mean. Hiyo joint partnership na co-partnership.
joint na sawa. Sasa unaona hadi hivi da ilikuwa ya ni kama brief kinda. Ndio sasa official, sasa nikiitisha nao the official meeting at least tutakuwa tuna flow, si ndio?
Sawa.
When do you suggest tutakuwa na ingine?
Itakuwa lini?
Sasa hiyo ingine
We have like
one day teo ni lini? Tuesday. So tufanye kesho asubuhi. Si ndio?
Kama watu watakana.
Sawa. Hadi nasileta hadi wasipotana up. Tutafanya sisi wawili tu, at least tutarudia kila kitu na hizo case law tutakuwa tumeshazitafuta poa.
But hapa so far umepeana tu mbili, Lloyd versus Grace Smith na hiyo Begil versus Miller.
Hizo ndo ziko kwa notes za madam tu.
Sawa, ina shida. Tutanitumia Partnership Act.
Sawa nakutumia. Sawa.
So imeisha.
Imeisha hivyo.
Okay, thank you.
Asante.
Bye.
Bye.